Well, the problem basically is that migrant workers, we always argue, should be protected by the labor laws of the host countries. Meaning, first you try to determine whether or not there's employer-employee relationship between the migrant worker and the establishment for which she is working. But the problem with regard to TISA and Mode 4 of other FTAs or Mode 4 under GATS is that if you try to deploy workers under the movement of natural persons, then these migrant workers will no longer be considered as employees. They would be considered as independent service providers, which means that you take them out of the labor law of the host countries. Instead, their contracts would be governed by the default or the general contract laws of that country. Now, obviously there's a huge difference between ordinary contracts and labor law contracts because given the asymmetry with regard to the bargaining power of the worker on one hand and the employer on the other hand, you cannot just put in provisions in the labor contract which are onerous. Meaning you cannot put that the worker can accept lower labor standards and the worker must accept lower minimum wage, etc., etc. In those cases, the state comes in and say, well, look, this is a labor contract, and then there are minimums that we have to comply with. So even though obviously there's a bargain for exchange between the employer and the employee, we will take that for we will basically set that aside, and we will say this is what should prevail. Meaning you should pay the minimum wage, you should respect all of the core labor standards of the ILO, etc. He or she can be allowed to join the unions, etc., etc. Now, the problem with regard to that is that if you're deployed under Mode 4, then you're not an employee. So the general labor laws do not apply to you. So it's as basic as that one.